welcome back to the main auditorium. I hope you had a nice lunch break and very interesting discussions during the breakout session. Let me now introduce you to our next keynote speaker, Mr. Ashkan Sultani. Mr. Sultani is the Executive Director of the California Privacy Protection Agency. He previously served as a senior advisor to the U.S. Chief Technology Officer in the U.S. White House Office of Science and Technology Policy under the Obama administration, and as the Chief Technologist for the U.S. Federal Trade Commission, where he helped establish the agency's Office of Technology, Research and Investigation. It will be great to hear from Mr. Soltani as to the U.S. perspectives on effective enforcement and the presentation of the California Privacy Protection Agency. Ladies and gentlemen, let me pass the floor to Mr. Ashkan Sultani, Executive Director of the California Privacy Protection Agency. The floor is all yours, Mr. Ashkani.
Morning. Hey, everyone. Good afternoon there. Thank you for the opportunity to join you via teleconference. I'm the Executive Director for the newly formed California Privacy Protection Agency. I've been following the conference discussion closely and have enjoyed the many perspectives provided these last 2 days. I'd like to take my time to briefly introduce our law and our agency, including our approach, in the hopes of furthering fostering dialogue between California and the EU. As way of background, some of you may know that the California legislature passed in 2018 the first of its kind consumer privacy law in the US, the California Consumer Privacy Act. Although a number of states such as Colorado and Connecticut have provided similar approaches since, California was the first to embark our citizens with certain rights with regards to their privacy. The law provided Californians the right to access, delete, and stop the sale of their information. It required businesses to provide notice at the point of data collection, outlining the purposes for which the data is collected and will be used, and the categories of third parties the data will be shared with. Importantly, it gave consumers a right to delegate to third parties, to other entities, the ability to submit requests on their behalf, to opt out and delete their personal information. It also directed the Attorney General of California to issue regulations to implement the measure and to enforce it. A key provision of the regulations is a requirement that businesses honor global privacy controls, privacy signals, as an opt-out of sale, so that users can protect their privacy in a single step rather than having to click on every website or service that they engage with. The CCPA also had strong definitions, for example, of de-identified and sale information to cover behavioral advertising by the opt-out. Then in 2020, California has voted to approve Proposition 24, an initiative which extends and amends the CCPA. This referendum was heavily informed by the GDPR, with lots of conversations with colleagues across the pond. The CPPA provides Californians additional rights, such as the right to limit the use of their sensitive personal information, a requirement for data minimization and a purpose limitation, a right to correct, and a right to have meaningful information regarding automated decisions and opt out of those decisions. Importantly, the initiative did 2 other key things. One, it guarantees a floor under which protections cannot go below, specifically allows amendments to the CCPA to improve and clarify, but requires that amendments be in furtherance of the purpose and intent of the act, which is to protect consumer privacy. It's a one-way ratchet that allows further protections. Secondly, it created our expert agency, including our budget, and tasked us with 3 key functions: rulemaking, providing guidance to businesses about the law, consumers and businesses about the law, and administrative enforcement of the law. We share enforcement with the Attorney General as well, who still has civil enforcement of the law, meaning there are effectively 2 enforcement authorities in California. The agency was created just last year when the governor, legislature, and Attorney General appointed our 5-member board. Then I was appointed last October by the board as the executive director. And importantly, my background, I'm not a lawyer, I'm a technologist. I worked heavily with attorney generals and as the FTC on enforcement. And I've worked with implementers and technologists to understand how both the law and technology work. Since I joined, our agency has been ramping up very quickly. We've been actively hiring and growing. We have offices now in Sacramento, as well as remotely across the state. We've also just released our 60-some page rulemaking package, which clarifies key aspects of the law, including, for example, expansion on the definition of dark patterns with regards to how interfaces are designed that might intend to seek to manipulate consumers' choice, and a furtherance of the global opt-out that allows consumers to singly enact their choices. Our rules also, our draft rules also lay out our administrative enforcement process, including our audit authority, whereby the statute provides our agency the right to conduct audits to ensure compliance with the law. We're also putting into place our process for handling sworn complaints, similar to what goes on in the EU. And in this, I've been speaking with a number of EU counterparts to better understand your experiences there with regards to handling and delegation of complaints. We're very excited, as this is effectively the first DPA in the US. We are in the process of essentially building up and representing ourselves as the first DPA. And our intent is to have equivalent expertise and capacity as our counterparts in the federal level once we're staffed up. And one quick note on that, you might have seen efforts recently to implement a similar federal framework than what we have in California. I personally think this is a positive development. However, efforts to preempt California could be problematic as we have these important provisions, as I laid out earlier, with regards to the law, protecting the law from being weakened, but also requiring that we have an expert agency with additional capacity to enforce the law. As such, any federal proposal will likely be weaker than what we have in California. But again, personally, I think it's important that others in the US have these protections, not just California, simply just not at the expense of California. Hopefully that gives you a bit of background about our agency. I look forward to continued conversations with our EU counterparts, both on our approach and our enforcement. I've already been in touch with a number of folks, but I do hope others reach out to speak with us. I hope that you look at our agency as a partner in enforcement and a partner in effective enforcement, as it's incredibly exciting work and detailed work. I'm very happy that you all had invited me to speak here today. I really look forward to continued dialogues and hope that we can have other opportunities in the future. Thank you very much.